Very much, Mr. Chairman. Mr. Chairman, my words are said this morning with considerable disappointment. I have great respect for you, Mr. Chairman, and for most of my colleagues on the other side. So let me begin with some history.
Some of those on the other side would say the same thing about their side.
Because we have some names.
All right, let me begin with some history. No Supreme Court seat has been kept vacant by Senate inaction for over a year since the Civil War. I think it's important to realize what that means in terms of history and a 4-4 court. First, some history. 155 years ago, last week, March 4, 1861, President Lincoln delivered his first inaugural address here at the Capitol building. Lincoln had won the election in November. As we all know, the nation was about to enter years of brutal civil war. Lincoln closed his momentous inaugural by appealing to avoid the bitter conflict that was to come. He said, and I quote, "We are not enemies, but friends. We must not be enemies. Though passion may have been strained, it must not break our bonds of affection." He then appealed to the better angels of our nature. Despite Lincoln's appeal, the war came. The first Battle of Bull Run happened in July 1861 in Manassas, Virginia, about 32 miles from here. There was real concern that Washington itself was at risk. Amidst all of this upheaval, there was a vacancy on the Supreme Court. Supreme Court Justice Peter Daniel died in 1860. President Buchanan sent up a nomination in 1861, 3 months after Lincoln's election, and only a month before Lincoln's inauguration. Multiple states had already voted to secede by that point. The nominee, Jeremiah Black, received a vote on the Senate floor. His nomination was rejected by a single vote. President Lincoln ultimately nominated Samuel Miller, an Iowan, Mr. Chairman, to fill that seat. Miller was confirmed in 1862. Mr. Chairman, that was the last time the Senate kept a Supreme Court seat vacant for more than a year. So it took our nation tearing apart and at war with itself for the Senate to keep a Supreme Court seat vacant for more than a year. And that was the last time it happened. No Supreme Court seat has been kept vacant by Senate inaction for over a year since that time. So what's happening today is contrary to our committee's practices, even in divided government and in election years. Also, no nominee for a Supreme Court vacancy has been denied a hearing since 1916, when the committee first started holding hearings on such nominations. That's 100 years of precedent. We have confirmed nominees in presidential election years. Most recently, a Democratic Senate confirmed Justice Kennedy, a Republican, in the final year of Reagan's term. 14 Supreme Court nominees, in fact, have been confirmed in presidential years. Clarence Thomas did not receive a majority vote of support in this committee, but still he was confirmed by a Democratic Senate in October of 1991, after the presidential election campaign had begun. I remember it clearly because it was during my first campaign for this body. In 2001, as Senator Leahy has said, Senator Hatch and Senator Leahy recognized our long-standing practice to give nominees fair consideration, a vote in the committee and a vote on the floor, and this was done in the joint letter that Senator Leahy referred to, and it was entered into the congressional record for all time. That was an agreement made in a Democratic Senate when a Republican, George W. Bush, was in the White House. It is this body's job, this committee's job, to look carefully at the nominee and give that person a fair hearing and a vote. The effect of this obstruction is likely to leave the court with only 8 members over 2 terms of that court, if you actually think about the timing. Now, what does that mean? Out of 8,000 petitions for review the court gets a year, this is according to the Supreme Court's website, the court takes about 80. It chooses those primarily where there's a disagreement among lower courts about important federal issues. Over 2 years, we're talking about 160 cases and 16,000 requests for review that are potentially impacted, not to mention emergency requests that do not have the luxury of time. Now, of course, the court isn't going to deadlock in every case, but the potential for deadlock is greatly increased when the court has only 8 members and the court previously was divided 5-4 frequently. Tie votes in the Supreme Court do not settle the dispute heard by the court, and they don't create precedent for other cases. This means uncertainty in the law continues, and the law varies around the country when it could have been settled. This is why, as President Reagan said before Justice Kennedy was confirmed, and I quote, "Every day that passes with the Supreme Court below full strength impairs the people's business in that crucially important body," end quote. Supreme Court justices themselves, including Scalia and Rehnquist, have noted the dangers of an evenly divided court. Justice Scalia decided not to recuse himself in 2004, saying that if he did, quote, "The court proceeds with 8 justices, raising the possibility that by reason of a tie vote, it will find itself unable to resolve the significant legal issue presented by the case," end quote. That should be sobering. Scalia quoted the court's recusal policy, signed by 6 Republican appointees, stating that, quote, "Even one unnecessary recusal impairs the functioning of the court," end quote. Now, we've gone through a lot of tie votes, and we have those. And when you actually go through them, you see the impact of a 4-4 divided court. Let me give you just one example. I picked it because it involves circuit. In 2008, the Ninth Circuit decided a case called United States versus Flores VR. The question was whether a person born abroad to an unwed U.S. citizen parent was a citizen of the United States. The law differed, depending on whether the citizen parent was the mother or the father. Here's how the Ninth described the issue. Quote, "If a United States citizen father had a child out of wedlock abroad with a non-United States citizen mother, the father must have resided in the United States for at least 5 years after his 14th birthday to confer citizenship on his child. But a United States citizen mother had to reside in the United States for a continuous period of only 1 year prior to the child's birth to pass on citizenship. It is this difference that Flores v. VR claims makes an impermissible classification on the basis of gender and age," end quote. The Ninth concluded that this disparate treatment was permissible under the Constitution, and so ruled against the individual claiming U.S. citizenship. The Supreme Court accepted the review in the case, but in 2010 it deadlocked 4-4 because Justice Kagan was recused. That left the Ninth's decision in place in California, Arizona, and other states in the Ninth, but did and other states in the Ninth, but did not set a nationwide precedent. 5 years later, in 2015, Morales-Santana v. Lynch, the Second Circuit came out the opposite way. Here's what the Second Circuit found. Morales-Santana argues principally that this statutory scheme violates the Fifth Amendment's guarantee of equal protection, and that proper remedy is to extend to unwed fathers the benefits unwed mothers receive under the statute. We agree and hold that Morales-Santana derives citizenship at birth through his father, end quote. So you see, a tie vote can have real significance. Here's the bottom line. Even today, in the situation presented by this case, children in one judicial circuit may not be citizens, but in another circuit they would be. That's not the fault of the child. It's all because of how the law treats parents of different genders. And it makes no sense when the issue could have been resolved 6 years ago in 2010. Let me just conclude by saying that the path Republicans have put us on goes against more than a century of history. It's going to impair the functioning of the Supreme Court. And no doubt members are going to point that out. I believe it's going to have, most importantly, real impact on people and real businesses in real cases, both this year. We all know the other side of the aisle has been trying for years to deny this president the right of appointment, whether it be for ambassadors, his cabinet, or other top-level staff appointments. But this is really something different. So I am appealing to the better angels of your nature. When there is a nominee, do as we've done in the past. Give the nominee careful consideration. Meet with the nominee. Ask the nominee questions. Hold a hearing. And then hold a vote, both here and on the floor. Vote no if you want. But let's have the fair process that's our tradition. That's our job, and we should do it. Thank you very much, Mr.